This conference is being recorded.
So I'll start in a minute. So is that in the middle of my? Okay. All right. Good morning. It is 10:07, and we're going to go ahead and call the meeting of the Commission on State Mandates to order. Welcome to our hybrid meeting. For those participating in person, I have some housekeeping information on the table near the wall. Our paper copies of the meeting, revised notice and agenda, revised new filings, proposed consent calendar, and witness list. The electronic public hearing binder is also located there on a laptop. Please note that the room has microphones, so speakers and microphones on all devices must stay muted for the duration of the meeting to eliminate feedback noise. When called up for an item, the parties and witnesses will please come to the table and sit at a designated laptop. The restrooms are located out the door and down the hall to the right. The women's restroom is across the open atrium. The key for both restrooms is on the table as you exit the conference room. Finally, please take note of the emergency exits in the room. For those participating remotely, the materials for today's meeting, including the revised notice, agenda, proposed consent calendar, and witness list, are available on the Commission's website at www.csm.ca.gov under the Hearings tab. When being sworn in at the beginning of the hearing and when called for an item, the parties and witnesses will please turn on their video and unmute their microphone. At the conclusion of the item, please turn off the video and mute the microphone. In the event we experience technical difficulties or the meeting is bumped offline, we will restart and allow time for people to rejoin before recommencing the meeting. Please remember to speak slowly and accurately for the benefit of the court reporter and an accurate transcript of the hearing. Finally, before we begin, it is my pleasure to introduce our new designee from the Governor's Office of Land Use and Climate Innovation, Matt Reed. Welcome, Matt. Matt has a decade of experience in legal government and nonprofit sectors. As the Governor's Office of Land Use and Climate Innovations, Acting Chief Counsel, Matt provides legal support to advance LCI's work to help California achieve its climate change goals through place-based, community-driven programming. Matt came to LCI from local government, where he served as a city chief of staff, managing a broad policy portfolio of housing, sustainability, homelessness, public works, transit, and active transportation issues. For the city, Matt worked at Breathe California and his own private practice, providing his expertise to nonprofit and foundation partners, advancing public health initiatives. Matt received his Juris Doctorate from the University of the Pacific, McGeorge School of Law, with a certificate in mediation. He attended the Willamette University in Salem, Oregon, where he received a Bachelor of Arts in Rhetoric and Media Studies and Politics. Matt, welcome to the Commission.
Thank you.
Juliana, will you please call the roll?
Mr. Adams.
Here.
Ms. Gallegos.
Here.
Ms. Green-Ross.
Here.
Ms. Nash.
Here.
Mr. Holland.
Here.
Ms. Peralt.
Here.
Mr. Reed.
Here.
Thank you. We have a quorum present, so we will go ahead and move now. Next is item 1. Are there any objections to or additional corrections of the January 24th, 2025 minutes? Seeing none. Are there any public comments on this item?
Madam Chair, I do not see any public comments online.
And any other further? Recording in progress. All right. Okay, excellent. Is there any other further comments or questions from the Commission members? Seeing none, is there a motion to approve the January 24th, 2025 minutes?
So moved.
Then moved by Ms. Nash.
Second.
Seconded by Ms. Green-Ross, I think. I'll get you next time, Mr. Ross. All right. Thank you so much. There's been a motion and a second. Juliana, please call the roll.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green-Ross.
Aye.
Ms. Nash.
Aye.
Mr. Holland.
Aye.
Ms. Peralt.
Aye.
Mr. Reed.
Abstain.
Thank you. That motion carried. We'll go ahead now and move on to public comment.
We will take up public comment for matters not on the agenda. Please note that the Commission may not take action on items not on the agenda. However, it may schedule issues raised by the public for consideration at future meetings. We invite the public to comment on the matters that are on the agenda as they are taken up.
At this time, are there any public comments?
Madam Chair, there are no online public comments.
Okay, and seeing none here in the room. So hearing no further public comment, we will go ahead and move on to the next item.
Next is the proposed consent calendar. Item 4 is proposed for consent.
Thank you. Are there any objections to the proposed consent calendar from the members or from members of the public? Seeing none, are there any objections from members online?
Madam Chair, there are no public comments or objections.
Okay, thank you so much. With that, is there a motion to adopt the proposed consent calendar? Moved by Ms. Gallegos. Is there a second?
Second.
Okay. Seconded by, and I've already forgot your last name, Mr. Reed. Thank you. I apologize. All right, we have a motion and a second. If we could please call the roll.
Mr. Adams?
Aye.
Ms. Gallegos?
Aye.
Ms. Green Ross?
Aye.
Ms. Nash?
Aye.
Mr. Polland?
Aye.
Ms. Peralt?
Aye.
Mr. Reed?
Aye.
All right, that motion carries. We'll go ahead now, moving on to our.
Will the parties and witnesses for items 2 and 3 participating remotely, please be sure that both your first and last names are listed on your Zoom window for the benefit of the court reporter. Turn on your video and unmute your microphone. The parties and witnesses participating in person, please approach the witness table, and all parties and witnesses, please rise. Will the parties and witnesses for item 2 please state your names for the record, beginning with the witnesses participating in person?
David Rice.
Department of Finance.
Kevin King with the City of San Diego.
Will the parties and witnesses for item 3 please state your names for the record?
Donna Thurby, Department of Finance.
This is Gregory Newmark for claimant City of Dublin, City of Union City, and the Alameda County-wide Clean Water Program.
All right. Do you solemnly swear or affirm that the testimony which you are about to give is true and correct based on your personal knowledge, information, or belief?
You do.
I do.
Thank you. Next is item 2. Chief Legal Counsel Camille Shelton will please present a proposed decision on lead sampling in schools, Public Water Systems number 3710020, 17 TC03R2. At this time, we invite the parties and witnesses for item 2 participating remotely to please turn on your video and unmute your microphone. And those participating in person, please come to the table.
Good morning. Test claim addresses a domestic water supply permit amendment issued by the State Water Resources Control Board to the City of San Diego and requires the city's public water system, beginning January 18th, 2017, to submit to the Water Board a list of all K-12 schools it serves, and upon a request of an authorized representative of a school made before November 1st, 2019, to sample and test drinking water in the school for the presence of lead. The courts have already determined that the permit amendment mandates a new program or higher level of service. Thus, the only issue remaining is whether there are costs mandated by the state. The courts have held that once a state statute or executive order mandates a new program or higher level of service, reimbursement is required for the increased costs unless an exception applies. The state cannot force local government to absorb the cost of the new state mandated program. Here, the city has filed evidence that its increased costs exceed the $1,000 minimum requirement for reimbursement. The State Water Board contends, however, that the city has the legal authority to increase property fees on all ratepayers, including the schools receiving the service, and thus the fee authority exception in Government Code Section 17556D applies to deny the test claim. Staff finds that the exception does not apply in this case. First, the permit amendment states that the claimant is responsible for all costs of the mandated program, and documents issued by the State Water Board at the time the permit amendment was adopted indicate that schools would receive the service for free. Thus, there is no authority for the claimant to impose any fees on the schools receiving the mandated service. Second, staff finds that the city cannot increase the water rates on the remaining ratepayers without violating Propositions 218 and 26, which require that the amount of a fee or charge imposed upon any parcel or person as an incident of property ownership shall not exceed the proportional cost of the service attributable to the parcel. This requirement ensures that the aggregate fee collected on all parcels is distributed among those parcels in proportion to the cost of service for each parcel. This requirement would be satisfied if all customers could legally share in the costs of lead testing. However, the claimant is prohibited by the permit amendment from passing those increased costs onto the schools receiving the lead testing, thus passing the increased costs onto the remaining customers, making the cost of service to their parcels higher than the cost of service to the schools receiving the additional lead testing, would violate Proposition 218 and would require the voters' approval as a tax under Prop 220. Therefore, staff finds that there are costs mandated by the state. Accordingly, staff recommends that the Commission adopt the proposed decision to approve this test claim and authorize staff to make any non-substantive or technical changes to the proposed decision following the hearing.
Thank you. If the parties and witnesses would please state your name for the record again.
Marilyn Munoz,
I'm
Department of
David.
Finance.
Kevin King with the City of San Diego.
I'm David Rice with the State Water Resources Control Board.
Very good, thank you. Mr. King, for the claimant, City of San Diego, would you like to begin?
Thank you. Yes. I'll just start with the point that the city disagrees with, and that's on the analysis, part of the analysis with Prop 218, and that's Article 13D, Section 6B4, which states that we can't charge for a fee or service unless the property owner can actually use that service. The commission focuses on water service as the service and says that everyone that's available to everyone, but I think that's the wrong focus here. The service should be lead testing, because that's what's at issue in the permit amendment, and only those schools receive the lead testing, so we can't charge other property owners for that lead testing. So again, the city disagrees on that point, but otherwise agrees with the decision, specifically on proportionality, as Ms. Shelton discussed. The evidence clearly shows that these schools have to get the testing for free. That's in the permit amendment, says that the water system is responsible for the costs. I think the water board got it right in 2017 in their press release about this. As the commission notes in their proposed decision, in the first line, it states that in an effort to further safeguard California water quality, K through 12 schools in the state can receive free testing for lead under a new initiative announced today by the State Water Resources Board. Again, it's the key word is free. And then in that same press release, it's reiterated, the board's new requirement ensures schools that want lead testing can receive it for free. So water board got it right then, and then the water board got it right again in 2018 when they commented on the test claim, and they said an important element of the lead testing in schools programs is that the requesting schools receive the lead testing at no charge. That's how the water board interpreted the permit amendment then. That's how everyone interpreted it. So I think the commission has it right in giving all of that evidence much more weight than the newly submitted evidence from the water board stating the water board's intent 8 years later. That's all I have.
Thank you so much, Mr. King. Ms. Munoz from the Department of Finance, do you have any comments?
Yes, the Department of Finance concurs with staff's recommendation for the adoption of the proposed decision.
Thank you very much. Mr. Rice from the State Water Resources Control Board and State Water Resources Control Board Division of Drinking Water, do you have any comments?
I do. Thank you so much. Good morning, members of the commission. My name is David Rice, and I'm an attorney with the State Water Resources Control Board. And thank you so much for the opportunity to address you this morning, especially since we're all here in this nice, intimate setting. This has certainly been a long road, and I want to commend the commission staff on their consistently excellent work on this matter. Although the State Board doesn't agree with the conclusion of the proposed decision, I appreciate the commission staff's consideration of our comments and, as always, very thoughtful analysis. You know, I actually remember when this test claim was filed in 2018, I had only been assigned to the Division of Drinking Water for about 2 months. And prior to that, I had served as the sole attorney for the Santa Ana Regional Water Quality Control Board for about 10 years. In that capacity, I had been involved in several test claims challenging stormwater permits. And actually, when I moved over to the Division of Drinking Water, I thought my mandate's work was done, but that was not the case. So when this test claim was filed in 2018, and it was assigned to me, I immediately called Kurt Souza. You may recognize his name because he testified during the first commission hearing on this matter back, I don't know when. So I immediately called him because at the time he was the most senior assistant deputy director of the Division of Drinking Water. And I recall that he was just completely surprised that the city of San Diego was claiming that they couldn't pay for these charges. And I recall him saying something to the effect of, this has just got to be budget dust. I mean, what is really the big deal? And it turns out he was kind of right, because according to the proposed decision, the city's cost of compliance is about $400,000. And when you compare that with its budget for the water enterprise facility, it's less than 1/1000th of a percent. I want to get that right. Less than 1/1000th of a percent of the city's annual budget. But more importantly, when you spread that cost out among all the customers, 1.3 million customers, you're talking about 40 cents per customer. And it's this small fee, or more specifically, who can pay this 40-cent fee, that forms the only disagreement that the State Water Board has with the proposed decision. But obviously, that is the real issue here. Who gets to pay that fee? Who's allowed to pay that fee, that 40-cent fee? The State Board agrees with the proposed decision that if the city could charge all customers the same 40-cent fee, that including the schools receiving lead testing, that the city would have fee authority and the test claim would be rejected. But the proposed decision concludes the test claim order itself, not the law, but the test claim order itself, prohibits the city from charging the schools that 40-cent fee, and therefore there is no fee authority. The State Board disagrees with that interpretation and respectfully submits that the more reasonable interpretation of the State Board's own order is that the city can charge the schools the same 40-cent fee as all other customers to cover the cost of compliance with the test claim order. So let's take a look at the plain language of the test claim order. To summarize the relevant portion of the order, which is in Section 5 of the directives, the test claim order requires the community water system cover all costs associated with complying with the order. And it does say all costs. Community water system must cover all costs: school testing, lab analysis, staff time, etc. And it is the use of this word all that the proposed decision really relies on to reach its conclusion. According to the decision, all means all. And so not only is the city prohibited from charging a separate fee, but the city can't even ask the schools to pay the same 40 cents as everybody else. The State Water Board has never interpreted this language so narrowly. The language in question only states that the community water system must pay for, but does not identify what revenues the city can use to pay for costs of compliance. How is the community water system supposed to pay for these costs? I submit the city can use the same revenues it uses to pay for most of its operations, the regular monthly fees that customers, including schools, pay. Nothing in the test claim language, nor the guidance documents, or the press releases says the city cannot use its regular customer revenues to pay for the cost of compliance. And given the small amount of money we're talking about, this isn't surprising. I think the underlying assumption, and frankly, this kind of explains why the State Board used the term free, is that they would just use their regular rates. The entire purpose of that language was that so the community water system of the city wouldn't shift the burden to the schools, which could have been several thousands of dollars. I don't think anybody was thinking about like an increase of 40 cents or what would have been 40 cents. And so that's why the term was used free or at no charge, because on a relative basis and in reality, it really is free and no charge. So my guess is this kind of what happened here and what had happened in response to the other 1,100 plus lead testing permits amendments issued to other public water systems. They just used the regular rates, including those submitted by the schools, and paid for the cost of compliance. So not only is this the more reasonable interpretation, but it's consistent with the intent of the language as stated in the declaration of Darren Polhemus, the Deputy Director of the Division of Drinking Water, which was submitted along with our comment letter. In his declaration, Mr. Polhemus provided the purpose of intent of the test claim language was to prevent the city from issuing a separate fee to the schools receiving testing. Again, it could have been $1,000. What that would have done is it would have chilled the desire of those schools to actually receive testing. But it was not, and I quote directly from the declaration, intended to, nor drafted in a manner to exempt a school from paying all normal rates. including any incremental charge associated with the cost of complying with the permit amendment requirements. Again, the intent was just to prohibit the community water system from shifting the burden of costs from the community water system itself to those particular schools. Didn't it all speak to how to use those existing rates and revenues that everybody pays? And I think it's worth mentioning is that as far as I can tell from the filings, the city never argued that the schools receiving testing may not need to pay the same 40-cent charge to their customers. This may be because the city was focused on different arguments, or as I suspect, it may be because not even the city interpreted the language to prohibit it from spreading the cost equally among other customers. So in conclusion, the State Water Board submits that when considering the language of the test claim order, the intent behind the language in question, and the underlying factual context, the most reasonable conclusion, the test claim order does not prohibit the city from spreading the cost equally amongst all ratepayers, including the schools receiving testing. State Water Board respectfully requests that the Commission reject the test claim on the basis that the city has fee authority under Government Code Section 17556B, and I'm happy to answer any questions, and thank you for your time.
Thank you. Are there any public comments on this item?
Madam Chair, I do not see any online public comments.
And I don't have any here in the room. So with that, I'll bring it back to commission members. Are there questions or further conversation, discussion from commission members on this item?
I have a question. Start with your argument. It boils down to all doesn't mean all at the end of the day, right? I mean, you're saying all doesn't mean a de minimis amount. That should be acceptable, but shouldn't any contract, order, statute simply follow the plain language used to create that contract, statute, order, et cetera? And so wouldn't then all be taken at face value, and then wouldn't that support the commission staff's opinion?
I think it does. I think that's a plausible interpretation, but I think given the context, the intent of the language, the way that I think everybody's interpreted the language, and the way that I think this played out in the real world, and just the very, very small amount, that it's more reasonable that what was meant by the language was that the costs wouldn't be shifted directly to schools, but that everybody could equally share in the cost of compliance.
Sure, but were that the case, then couldn't a word other than all have been used, or a phrase other than all, if the intent was truly to require de minimis costs be passed along? That could have been drafted into the language, but intentionally wasn't.
Yeah, well, I don't think that it was intent. Certainly the language was, it could have been drafted better, but I don't think that leads to the conclusion that the proposed decision reaches to be the most reasonable reading of that language. Could the language have been better? Absolutely. But I think at the time, what we were concerned with was really just shifting the burden of, as I explained, of several thousands of dollars, and that at the time, the intent had nothing to do, I don't think anybody, frankly, was even thinking about the possibility that, 40 cents or $1 or whatever it is couldn't be shared equally by everybody.
So I don't intend to put words in your mouth, but I think what I'm hearing is the plain language of the words used would support the commission's opinion, but you're seeking, kind of collateral sources to, argue for a different intent, and therefore result different than the excuse me, proposed decision.
I think that the language is a little bit ambiguous. So I think when all means all, I think within the context of in the context of the way that fees are actually distributed and the way that things are paid for, and that the intent as identified by the deputy director, that while the commission's conclusion is plausible, I just don't think that it is the most reasonable read of what that language really means.
No further questions from me.
Is there any other additional questions from the commission members? Yes.
Madam Chair, just a comment. I was on the commission when we first decided this, and We had talked about whether this was a mandate or not because the city decided to go into the water business but was not mandated. And I just find the whole concept of, legally compelled and practically compelled very, very interesting. And when that shifts for local government to make that argument. So this is a fascinating subject. Thanks.
All right, other comments? Okay. So seeing none, is there a motion?
Madam Chair, I would move the staff recommendation.
Okay, I have a motion by Mr. Adams. Is there a second? Second by Ms. Green Ross. If you could please have a roll call.
Mr. Adams?
Aye.
Ms. Gallegos?
Aye.
Ms. Green Ross?
Aye.
Ms. Nash?
Aye.
Mr. Polland?
Aye.
Ms. Peralt?
Aye.
Mr. Reed?
Aye.
We now ask the presenters participating remotely for item 2 to please turn off their video and mute their microphones, and those presenting in person to please return to your seats.
Thank you. I apologize for the small pause, but my computer has just informed me it's going to update itself, and I have no choice, but it's going to shut down in 5 minutes. So I'm wondering if I should either move or if I can get it to restart now and take a short break.
I would take a recess.
Okay, so if we could do that before we move to item 3, I will force it to do it now. These are always untimely, I feel like.
Yes.
We will take a short recess at 10:33, probably 5 minutes. Hopefully it doesn't need that many updates, and then we will be back online to resume item 3. Is that
Very
fair
good.
enough? Okay, thank you. And again, my apologies.
This is when the machine takes over.
All right, thank you so much. I appreciate everybody's patience. When technology tells you it's going to do something, I guess sometimes you're just forced to listen. So luckily it was a quick update to the computer, and we're going to go ahead and resume our meeting here at 10:39. And we're going to go ahead and move on now to item 3.
Very good. Chief Legal Counsel Camille Shelton will please present a proposed decision and parameters and guidelines on California Regional Water Quality Control Board, San Francisco Bay Region, Order Number R2-2009-0074, 10 TCO2, 10 TCO3, and 10 TCO5. At this time, we invite the parties and witnesses for item 3 participating remotely to please turn on your video and unmute your microphone.
Good morning. These parameters and guidelines address the state-mandated activities required by the 2009 stormwater permit issued by the San Francisco Bay Regional Water Quality Control Board. The Commission partially approved the test claim at the January hearing for costs incurred to perform the mandated activities from December 1st, 2009 through December 31st, 2017. Draft expedited parameters and guidelines were issued in January and no comments were filed. Staff recommends that the Commission adopt the proposed decision and parameters and guidelines and authorize staff to make any technical non-substantive edits following the hearing.
Thank you so much. Would the parties and witnesses please state your name for the record?
Gregory Newmark, for the claimant City of Dublin, cities of Union City, and the Alameda County-wide Clean Water Program.
Donna Furby, Department of Finance.
Donna? And do we have anybody from State Water Resources? No. Okay. All right. Okay. All right. Thank you. Then we'll go ahead and move. Mr. Newmark, for the claimant, City of Dublin, would you like to begin?
We didn't submit any comments. We support the staff's recommendation, and I just would like to express the program of my client's appreciation for commission staffs moving these forward so quickly. So thank you, commission staff, for the hard and expeditious work.
Thank you. Ms. Farabee from the Department of Finance, do you have any further comments?
Hi, thank you. I'd also say thank you to the commission staff as well. And as to this matter, Finance has no comments to add. Thank you.
Thank you. Are there any public comments on this item?
Madam Chair, I do not see any online public comments.
Okay, thank you. And it appears we have none in the room. So I'll bring it back to the commission members. Are there any questions or further conversation from commission members on this item? No? Okay. All right. Well, with that, is there a motion either to adopt staff recommendations or otherwise?
Move to adopt.
Moved by Ms. Green-Ross. Is there a second?
Second.
Second by Ms. Nash. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green-Ross.
Aye.
Ms. Nash.
Aye.
Mr. Polland.
Aye.
Ms. Peralt.
Aye.
Mr. Reed.
Right, that motion carries.
We now ask the presenters participating remotely for item 3 to please turn off their video and mute their microphones. Next, Program Analyst Jill McGee will please present item 5, the legislative update.
Good morning. The following are the legislative updates since the last time the Commission met. First, SB 799, State Government, Local Costs. SB 799 was introduced by Senator Allen. This bill amends Government Code Section 17552 to include non-substantive changes. On March 12, 2025, this bill was referred to the Senate Rules Committee. Next, AB 964, Commission on State Mandates, State Mandates. AB 964 was introduced by Assembly Member Hadwick. This bill amends Government Code Section 17558.5. This bill would require the controller to notify the claimant in writing within 30 days of any adjustment that results from an audit or review and require the controller at its sole election to allow a local agency or school district to offset any reduced reimbursement as prescribed or to remit funds to the controller. On March 10th, 2025, this bill was referred to the Assembly Committees on Local Government and Education. Next, AB 1452, State Mandates, Claims. AB 1452 was introduced by Assembly Member Ta. This bill amends Government Code Section 17564. This bill would change the minimum claim amount that requires the state to reimburse a local government from $1,000 to $800. On March 13th, 2025, this bill was referred to the Assembly Committee on Local Government. Finally, SB 470, Bagley-Keene Open Meeting Act, Teleconferencing. SB 470 was introduced by Senator Laird. This bill amends Government Code Section 11123.2 and amends and repeals Section 11123.5. The act authorizes a multi-member state body advisory body to hold an open meeting by teleconference pursuant to specified requirements. Existing law repeals these provisions on January 1st, 2026. This bill would delete the January 1st, 2026 repeal date, thereby authorizing the alternative set of teleconferencing provisions for multi-member state advisory bodies indefinitely. On March 12, 2025, this bill was set for hearing in the Senate Committee on Governmental Organization, and on March 25, 2025, it passed and was re-referred to the Senate Judiciary Committee. Staff will continue to monitor legislation for bills that impact the mandates process. Thank you.
Thank you.
Thank you, Jill. Next, Chief Legal Counsel Camille Shelton will please present item 6, the Chief Legal Counsel report.
Good morning. The commission is not involved in any pending litigation, so I don't have any updates for you today.
Thank you, Camille. Item 7 is the Executive Director report, and I have 5 information items for the commission. First, new commission staff. Senior Commission Counsel Laura Doherty, please come to the table. I am pleased to introduce Laura Doherty, who recently joined commission staff as the Senior Commission Counsel Attorney 4. Ms. Doherty brings over 16 years of experience as a practicing attorney. In her most recent role at Howard Jarvis Taxpayers Foundation, she advanced from Senior Staff Counsel to Director of Legal Affairs, where her practice focused on constitutional law and government finance. She has argued in both state and federal trial and appellate courts, as well as drafted amicus briefs, a petition for review to the California Supreme Court, and 2 petitions for writ of certiorari to the U.S. Supreme Court. Ms. Doherty graduated from McGeorge School of Law with honors. During her studies in law school, she found a passion for legal research. She has a Bachelor of Arts in the French language. Ms. Doherty started with the Commission on February 13, 2025. Welcome to the Commission, Laura, and thank you for joining us this morning.
Thank you, Juliana.
Bonjour.
Bonjour, everyone. Thank you for making me blush. That was a very thoughtful introduction. It's been wonderful meeting everyone, and it's wonderful continuing to meet everyone. Looking forward to many years of service. Thank you.
Thank you.
Thank you. Welcome. Item 2, the Commission's 2025-2026 budget. The Governor introduced his proposed 2025-2026 budget on January 10, which includes the Commission's operating budget of $3.438 million. This is a decrease of $124,000 from the last budget after adjustments for salaries and benefits. The Governor's budget also includes $91.456 million for local assistance or local agency mandated programs. This is a decrease of $40.771 million. Please see my report for more detailed information. We have a regulations update. The subject of our 2025 rulemaking will be a full review and update of the Commission's regulations. Staff has prepared draft proposed amendments, which will be reviewed and discussed with local and state agencies at an informal conference, which will be set in April. After reviewing the informal conference feedback and making any necessary changes, staff will have the proposed language in the order to initiate rulemaking with the rule package for the Commission's consideration at the May hearing. Workload. As of March 1, 2025, there are 37 pending test claims, 32 of which are regarding stormwater NPDES permits. There are 4 parameters and guidelines, 4 statewide cost estimates, and 1 IRC pending. Tentative agenda items. A reminder to please check the tentative agenda items on the Executive Director's Report or use the pending caseload documents on the Commission's website, which are updated at least bi-monthly to see when something is tentatively set for hearing. Draft proposed decisions on all test claims and IRC matters are issued for review and comment at least 8 weeks prior to the hearing date, and a proposed decision approximately 2 weeks before the hearing. That's all I have, Madam Chair.
Thank you so much. Any comments or questions from the Commission on any of the reports? Okay. Well, we will go ahead now and move into and recess to closed session. Commission will meet in a closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The Commission will also confer on personnel matters pursuant to Government Code Section 11126A1, and we will reconvene in open session in approximately 10 minutes. Thank you. Are we ready? Yeah.
Mine too today too.
Is that coming down?
Yes, that needs to come down.
I was waiting. Okay. All right, great. Okay, we're good? Yeah. All right, thank you so much. Okay, it's 11:04. The commission is going to go ahead and reconvene public session. The commission met in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission also conferred on personnel matters pursuant to Government Code Section 11126A1. With no further business to discuss, I will go ahead and entertain a motion to adjourn. Is there a motion?
So moved.
Moved by Ms. Nash. Is there a second?
Second.
Second by, I'm going to second it by Mr. Reed. We'll give him that one. It's been moved and seconded, so to adjourn the meeting. So Juliana, please call the roll.
Mr. Adams?
Aye.
Ms. Gallegos?
Aye.
Ms. Green Ross? Ms. Nash? Mr. Polland? Ms. Peralt?
Aye.
Mr. Reed?
All right, the motion carries and the meeting is adjourned at 11:05. Thank you so much.